Share my screen and my sound. Everything is shared. Okay. So this week we are doing case law, finding cases, and then a bit about updating your research, because updating the research, making sure you found good law is kind of critical. So sort of format as always, cases and updating statutes sort of in a quiz format, followed up by 2 of my research tips. Hopefully we can go quick enough that there are some Lexis and West, there's a Lexis and a Westlaw exercise I prepared for you guys to go log into these platforms and see if you can find what I'm asking. And then I'm going to end talking about the legal research project that will drop on Twin either tonight or tomorrow morning, and it's due Saturday the 6th. So that's what we're going to do today. So pop quiz. What's meant by the term stare decisis? You know what that is? Yes. Oh boy, 2 people raised their hands. Caitlin.
Let the decision stand.
Let the decision stand. Okay. That's correct. So the premise of that is, so Latin, to stand by things decided, the doctrine of precedent. So basically, unless a court of a higher level has overruled a decision, that decision of the court should be followed by all of the other courts in its jurisdiction. So stare decisis, we're going to follow the rule of precedent. So if the appellate level courts in Pennsylvania have ruled on an issue, that ruling should be followed by all of the trial courts below it up until the point the state Supreme Court has overruled that decision and made a new decision. Hopefully that's clear. Again, on precedent, question 2 here. How much weight, we've covered this before, should a New York trial court give a Pennsylvania Supreme Court opinion generally? I want to make sure that this is clear too. Yes, Rachel.
It could be persuasive authority possibly, but it won't actually have, like, they don't have to go based off what New York did.
So outside the jurisdiction, outside the jurisdiction, it's always going to be persuasive. It's never going to be mandatory. So if you find a Pennsylvania Supreme Court opinion deadlock on your situation, but you're in New York, you can only throw that at the court as persuasive evidence. You cannot hope to rely on it to persuade the judge in your jurisdiction. So yeah, what I just said there. So basically, if there's a novel issue of law and your jurisdiction hasn't covered it, you can throw it. But most of the time, you're going to need to stay in your jurisdiction. So question 3, this is sort of going back to the old days of legal research. What is a reporter? Do we have any idea what is meant by a reporter? Is it I've got a Kayla Johnson. Yes, ma'am.
It's a book that publishes cases that have been decided, or case opinions.
Correct. That's where opinions are printed, at least under the premise of where it's printed, so you can get a citation for a case generated, so that somebody reading your opinion will know where to find it by citation, either on Lexis or Westlaw, or in a law library, you can go to the print volumes of that reporter and pull that opinion off the shelves. So like it says there, it's mainly for citation purposes only in your brief. So other people can quickly find the opinion that you're relying on. So they know that you're not just making up an opinion or whatever. So traditionally, the official reporter will lack editorial enhancements. There may be summary, there may be some head notes, but the unofficial reporter, like for Pennsylvania, all of the opinions are in the Atlantic Reporter published by West. And these unofficial reporters will have summaries, they'll have head notes, and they'll have topic and key numbers assigned to these head notes, where you can more easily find cases that are similarly situated to a case you've already found. So you can use a topic and key number that you see on Westlaw and click on that topic or key number and find other opinions that are similarly subject matter organized. So it's the topic and key number is a finding tool. So they started it way back in the day when it was only print, and then they've carried it forward to the electronic platforms. Why does the official reporter distinction matter? Any thoughts on that? Because there are a lot of reporters. Some states have their own. Some states have their own electronic reporter system, but it's not an Atlantic reporter site. Yes, Kayla Johnson.
For citation purposes, you put, or you always cite to the official reporter first?
Correct. So, right, citation, the blue book, at least in your law school environment, typically the blue book rules how you cite to a case, whether it's to the Atlantic Reporter, whether it's to the Pennsylvania reports, etc. Out in practice, it may be you're not using the blue book, so you're going to go to the court rules, and the court rules for your court will tell you how to write the opinion. So here's a screenshot of the blue book, the Pennsylvania cases, and you can see here. So for Supreme Court opinions, you cite to it if it's in the Atlantic Second, or the Atlantic Third, if they're in. So if your Pennsylvania opinion's not in the Atlantic or the Atlantic Third or something, and then it'll start giving you a laundry list down the lines of other acceptable forms of reporters that you can cite to. But 90% of the time, you're going to find reported opinions in the Atlantic or some sort of reporter that's mentioned in the blue book. So here's a screenshot. It's from Westlaw. It's a Westlaw screenshot from a case, the Schmel v. Wegland case here, dealing with child custody. Up at the top of the screen, when you're reading the opinion, you'll see two instances of citation here. 592 PA 581, that's to the Pennsylvania Reporter. Volume 592, page 581, Pennsylvania Reporter. And then the parallel site, 927 Atlantic Second. So that's the Atlantic Second Reporter. So in the blue book, you would cite the 927 Atlantic Second site pursuant to the blue book. So Lexis and Westlaw, they'll frequently give you parallel citations to other reporters that have that opinion. Here's a tricky one. Can you cite to an unreported opinion? A lot, since we're on Lexis and Westlaw, and they go out to the courts and they do all of these vast batch downloads, they upload reported opinions, they upload unreported opinions, they upload memorandum opinions. So if you come across a case that's on point, but it says up at the top of the screen on Lexis or Westlaw, it's an unreported opinion, can you cite to it? One for yes or two for no. We're doing a chat bomb. One for yes, two for no, and 1, 2, 3, hit your button. Let's see what we think. I hope I don't break my internet connection here. It looks like the consensus is number 1. Yes. My answer is maybe. Back to check your court rules. In some jurisdictions, you can cite to a unreported opinion. In other jurisdictions, you can't. In Pennsylvania, the Pennsylvania Rule of Appellate Procedure tells you you can. When citing authority, as used in this rule, non-precedential decisions referred to an unprecedented. So you can recite to an unprecedential opinion for authority in Pennsylvania. All right, but in other jurisdictions, you may not be able to. So check your court rules. In this case, for legal methods, I think your professors may have a rule about that if it's all opinions or just reported. So make sure you're clear on what you can and cannot cite to. So following up on the court rules, where do you find court rules? Online. So court websites, 1, Westlaw or Lexis 2, or 3, all of the above. 1, 2, or 3. In 1, 2, 3, hit your chat. Okay, good. For the most part, all of the above. So in print, at your firm law library, they may have the print volumes, not the print volumes, the print versions of your local rules of court, your Pennsylvania rules of court. It's easier to thumb through the rules in print sometimes. So libraries will have them. Go to the court's website. They'll have their local court rules. The federal rules of civil procedure will be out there on the federal court's website. And then of course, Lexis and Westlaw will have them available too. So for citation purposes, would you cite to the language in the head note? In the head note of a case. So on Westlaw at the beginning of an opinion, you'll see these things called head notes, and Lexis has their own versions of. Head notes are nice, efficient ways of navigating the case. Each head note is going to talk about a very narrow aspect of the law or the holding. So if it's a long opinion, you're only dealing with a very narrow aspect of it. You can quickly click on the head note and get down to the meat of the opinion that's dealing with it. So it's more of a navigation tool to make your research easier. But would you cite to a head note? Any thoughts on that? I'm seeing a lot of people shaking their heads. Caitlin, I'm guessing your answer is
No.
no. That's right, because the head notes and all of these editorial things online, that's just done by the editors of Westlaw and Lexis and whatever platform you're using. You're going to want to scroll down to where it says opinion and actually cite to the official part of the opinion that was written by the judges when you're citing. So of course, 2 guesses, it doesn't take 2 guesses. So question 8, so how do you go about, where are judicial opinions found? In general, where are they found? They're in the reporters, right? So where do you go to find a reporter? go to a library and just walk around? Kayla,
Well, you can go to a law library or you can look on Westlaw or Lexis.
okay, the Lexis Westlaw, of course. A lot of times, if you're out in the real world and you don't have Lexis or Westlaw, the courts will upload opinions. In the library, find reporters, of course, but that's becoming rare and rare that we're actually going to have shelves of reporters on our library shelves anymore because of spacing purposes and budget concerns. So it's primarily going to be online going forward. But basically, here's your list of things. Again, back in the day, print reporters, there's the official reporter, US reports, PA reports, and then the regional reporters. Those were the ones printed by the West people with the annotations, the enhancements, the topic and key number treatment to it. But anymore, you're going to rely on subscription databases or the court websites at AOPC.org, Administrative Office of the Pennsylvania Courts. They upload most of the appellate decisions. So it's going to be clunky to find the opinions, but they are up there, especially if you have a site. So for the big chunk of the rest of my presentation, here's the scenario I'm operating under. We got a buddy. He's the starting quarterback on the Widener football team. And unbeknownst to him, he found out that that a local cheesesteak joint in Chester is using his voice on a radio commercial saying that it's the greatest Chester metro area cheesesteak joint in the entire world. But he didn't give approval to have his voice that was recorded from an interview in the radio. So does he have a cause of action to make them pull down the ads? Of course, we've never handled this sort of case, right? So first, I'm going to take you briefly through history. In the old days, the print reporters ruled all the land, right? Because Lexis and Westlaw were new. So not everything was available on Lexis or Westlaw. So you might have Westlaw, but you wouldn't necessarily rely on it because not all of the opinions would be uploaded. So you were forced to often use the reporters. Yeah, I use that terminal too. So Lexis and Westlaw, they didn't have all of the opinions. It was expensive and limited content. So the print, what were called digests, were the efficient starting point. So basically what you did, if I could get my silly thing to advance, is you would use the West Digest system. So West Pennsylvania Digest, Westlaw would go out, get all of the opinions, publish them in the reporter, and then they would create the digest as a finding tool for all of these hundreds and thousands of opinions. You would go to the descriptive word index and you would use it like any other index that you've ever used in undergrad. And you would hope to find a broad topic. So the entire body of American law is broken down to 400 some broad topics and then into very narrow key numbers. So you'd hope to find a topic and key number that was on point. So you'd find a topic and key number. The broad topic would be maybe torts, right to publicity, and the key number would be 389. So torts, 389, voice, the use of voice likeness. And then the digest would have these paragraph summaries. These are sort of like the notes of decision that you're going to find on Westlaw right now, connected with a statute. Paragraph summaries of opinions, and then this citation to the federal supplement where you would go and actually see this opinion. This this Fonseca opinion, which says, no, you're really not supposed to use the voice of somebody in a commercial without their opinions. So that's the old days. So how do you guys research cases? By citation. If somebody's already found an opinion, your managing attorney has a case on point, you'd write down that citation, type it in, find it by a secondary source, hoping to find a mention to an opinion. If you have a statute, you'd use the annotated statute to go to the notes of decision, which would be the summary of cases. Then you'd click on the links to pull up the opinion. Subject and digest. Electronically, you can use topic and key number electronically. So both on Lexis and Westlaw, you can do a subject matter type search rather than a keyword search. So it just sort of all depends. There are a variety of avenues for finding things. So obviously the citation. So log into Westlaw, log into Lexis. On your search bar that's at the top of the login screen, type in the Facenda. That's the Facenda citation that was in the print version, 488 Fed Sup second 491. Hit enter, and Facenda comes up. Of course, here's one of the problems with print research. The citation that was in the digest has a red flag. It's already been overruled. So the time delay between print and updating is already off kilter. So you'd go online, pull Facenda, you'd see why it's overruled and see if you could find another case that's probably better law. So from a secondary source, log into Lexis, log into Westlaw. Probably narrow my jurisdiction to Pennsylvania, type some keyword terms, right to publicity as a phrase in quotes, and then and voice. One of my initial hits was cause of action for infringement of right of publicity. And then I could do a control find. I go down to Pennsylvania, and they at least give me a couple of cases there that are dealing with the use of voice and the right to publicity. So at least I've got sort of a launching off point. These two opinions might have something to do with the right to publicity, the use of a voice, and probably within the opinion, it would give me the cite to the statute if there's a statute that controls the situation. So annotated statute. So you do your research, you come down with 10,000 hits, you click on statutes. You might that Title 43 of the Pennsylvania Consolidated Statutes, this section here statutorily deals with unauthorized use of name or likeness. So chances are, if you're going to help out your quarterback buddy, it looks like your cause of action is going to flow through the Pennsylvania statute. So you're going to read through the statute, click on the what am I thinking of? The TOC, table of contents, to see other sections around it. Scroll to the bottom of 8316 to the case notes. So these are all opinions dealing with this section. They give you a link back to the statute there. Here's my Fonseca opinion. So that's included in there, plus whatever other opinions are tied to these case notes. And the Westlaw annotated version would be similar. If I liked Lexis, I might think to use the subject matter search. So from your Lexis home screen, you can, at the bottom of the page, click on subject, and then go into a subject search. I went subject, and then I clicked on torts. I searched for right of publicity. and these cases came up. So that's another way of finding cases on a topic, on a subject, is use the topic approach. Similarly, the West subject search, if you log into Westlaw Next, on your home screen under content types, there's a key numbers. There's a key number link there. Click on that. Do search on right to publicity and voice, and you'll get a list of opinions that have been classified by topic and key number. So again, my Facenda case shows, but red flag, it's probably been overruled or there's something really negative about it. So I'm going to want to use Facenda to hopefully find other opinions. So probably most important part of my lecture is how do you know that a case or a statute for that matter, how anything is still an agency opinion, a case, a statute, how any primary authority is still good law. How do we figure that out? What do we do? In general, what's the mechanics of it? Caitlin?
On Lexis, you can shepherd the case and like click the little icon beside it, and it'll let you know if it was like affirmed or overruled.
Okay. Dylan, did you have something to add?
I was going to say base it off of the symbols that are represented on the case.
Okay. Yeah, that's the, Rachel.
I was also going to say there's the little stop sign, but it doesn't necessarily mean that it's not good law. It will tell you what it means.
Yeah, this Lexis and Westlaw, they're expensive because they hire a lot of attorneys to annotate the cases, the statutes, put in all of these flags and help navigate you through. But again, it's just what they think. So it's not necessarily dispositive of something else. So you use all of the add-ons for Lexis and Westlaw as sort of a guiding tool, but you don't necessarily want to rely on them exclusively. Just because there's a red stop sign doesn't mean the entire case is bad. It may have only been over for a procedural aspect rather than a rule of law aspect type thing. So yeah, Keysight or Shepherd. So Shepherd's for Lexis, Keysight is what Westlaw calls it. What do you get when you Shepherd or Keysight? You get primarily these four things. You'll get the prior history of the case, so the lower court's opinion, or if it's a middle court, you'll get, if there's subsequent history, you'll get the subsequent history, the appellate history. You'll get all of the hopefully all of these citing opinions, so any decision that is cited to the case you found. So if you found a case on point, that's the first way of finding other cases that are on point, is to see what courts have cited to it. There may be something a little more recent that has relied on it. Those recent cases may be closer to your fact pattern than the one you found, etc. And then also in the Shepherds and Keysight reports, you'll find links to other sources that have cited it. Law review articles, practice materials, causes of action, things like that that have interpreted your opinion. So if it's a complicated opinion that's sort of hard to digest, you might want to go to the secondary sources and see how other people have understood it. It might help clear your mind. Do be aware of the results for these Keysight and Shepherd signals may be different. So here's the Citizens United case where the Supreme Court says that people. So I do a Keysight for Westlaw for negative treatment in the Third Circuit. Westlaw says there are 20 of them. And Lexus says there are one. So how these two platforms analyze and assign the labels of neutral treatment, negative treatment, it's going to vary between the two platforms. So the moral of that story is you can't necessarily rely on the flags. Are the flags accurate? Westlaw has this thing that's called overruling risk. So while Childress v. Hackler is still a good law, they've also got this thing called overruling risk that says, hey, before you rely on Heckler here, make sure that this Chadkin case that Heckler relies on doesn't get overruled in the Louisiana Ninth Circuit. So that's a bit into the weeds. That's more for out in practice. But again, the flags, they can change in an instant. That's the moral of that story. So bottom line, Keysight Shepherds, update your research. Critically important. Do not forget this step because you don't want this to happen to
Founded
you.
allegations will change the truth.
Why don't you address the legal issue on motions to reconsider, Counsel?
Yes, and I meant to start with that, Your Honor. I got sidetracked.
That would help.
There is no, I'm sorry. There is no legal provision for a motion for reconsideration in criminal law. That is only in civil law. It is recognized in Civil Code of Procedures, Section 1008. And what they require in civil law is that the party seeking reconsideration show newly discovered facts. In this case, we have no newly discovered facts with respect to the motion for reconsideration of Laura McKinney.
But doesn't the case law dealing with that particular code section include criminal cases? If you shepherdize that, you come up with some criminal
We
cases.
did. I believe that none were found, Your Honor. We don't have any in our motion, which leads me to believe that no, there aren't any criminal cases under that section. And
Sure.
you asked me that question because you knew Ms. Lewis wrote the motion, huh? But no, as far as I know, there are no criminal law cases that involve that section because it's not recognized in criminal law. So, I mean, at least in theory, we didn't have to have all the argument. But
So if my Pepperdine law clerks found some,
did they? Criminal cases? And what do they say?
say it's
So Marcia in the O.J. Simpson case, I guess she didn't run Shepherd, so she thought this rule only applied in civil cases and not criminal. But they didn't update their research and they got cooked by the judge. So remember, when you find a case, when you find a statute, the Keysight, click on the Shepherds and run your thought process through all of those other opinions that have somehow dealt with what you found, just to make sure that it hasn't been overruled or whittled away. So here's a Westlaw research scenario I'd like you guys to run. Log into Westlaw and see if you can find an answer. In Pennsylvania, is a hotel or motel owner liable for the injury to a guest who slipped in a snow-covered parking lot after it had snowed the night before? So it snows on Friday night, the patron comes out Saturday morning, falls down in the parking lot, and is now suing our Motel 6 for not clearing the parking lot in time. Do we think liability potentially could attach in that situation in Pennsylvania? And if any, when somebody finds an answer, please raise your hand. Yes, Aaron.
I believe that I found some case law related to this issue in regards to Moran v. Travelers Rest Motel, Inc. And the Supreme Court, or I'm sorry, the Superior Court of Pennsylvania found that the hotel owner was not liable for the snow that had accumulated on the night before.
That's
I-
correct. Did you pick up on what the principle of law is? Hills and, is that right?
I'm so sorry you skipped out. Can you repeat that question?
And why was that? Is it the Hills and Ridges doctrine?
Yes, sir, it is.
Yeah. And did you Keysight or Shepherdize? Is it still good law?
I did not do that yet, but there's a yellow flag on it.
Click on the yellow flag, see what it says. Yellow flag just means warning, potentially negative treatment. So it's likely still good, but
It's just a holding was recognized by the Superior Court in 2006.
and is it from the same jurisdiction?
I can't tell that. I can't tell that answer, or I
Okay,
don't know that answer. I apologize.
okay, fair enough. Okay, yeah, good job. So Warren v. Travelers, that's the opinion I'd find in that situation as well. Yellow flag, potential negative treatment, but Warren hasn't been overruled, so you'd be able to rely on it. The opinion was distinguished by somebody else, but it wasn't overruled by a higher court. So you're not nervous to use Warren if you want to. So on Lexus, let's do this again, a very different fact pattern. In PA, can someone trim the branches that overhang from their neighbor's tree without first asking permission? So my neighbor to the right of me, his tree is like always overgrowing my fence. Can I go out there, well, when it gets warmer and lop off the tree limbs that hang over my property without asking his permission first? This one's giving us a little more of a hiccup. Okay. I did want to point out the difference. Here's the Moran v. Travelers opinion on Westlaw and Lexus. This is where the flag treatment is a little bit different again on the two platform. In Moran, for Westlaw and Moran, it's showing one negative case. In Lexus, it's showing 5 negative cases. So again, it's still good law. The editors of the two platform have treated it slightly different. So don't rely on the flags. More in here, it's been distinguished. That means usually that the fact patterns are slightly different. So they're not going to apply more in full. So Let me see if I can run this through. Lexis here. Come on, baby. Go to Lexis. Lexis Plus. I'm going to filter by state because I know I'm in Pennsylvania. Okay. Let's see. Neighbor, boundary. No, go by legal phrases. Neighbor, neighbor, boundary. Trees, neighbor, boundary. I'm going to use West Lexis's canned suggestions. Secondary materials. Yes, Jules.
I found a case on Lexis, Jones v. Wagner, which
Yeah.
is, it says that a tree branch overhanging would constitute as a trespass and that the person would be entitled to remove it. I'm not sure if that's the answer we're looking for.
Yeah, that's one of the answers, because you can see I use Lexis's canned tree boundaries neighbor search. And under cases, the Jones v. Wagner opinion was the second one they mentioned. So yeah, using the self-help doctrine, you can go trim your neighbor's branches without asking permission first. In Jones v. Wagner, he went one step further and he trimmed like a whole orchard row of limbs instead of just one, and that was still good. So Jones v. Wagner. Here's my little warnings. Caution, positive, neutral. They don't categorize anything as negative. I might want to click caution and see who cautioned it. A district court opinion and a Commonwealth Court opinion. So lower level opinions. It's not a Supreme Court opinion or anything that could have overruled the Wagner opinion. So if the Jones v. Wagner opinion fits into my fact pattern and helps me, I would feel comfortable in relying on that. So those are the sorts of things, the Westlaw, Quayside, and Shepherds, that you have to constantly be doing to make sure that what you're reading hasn't been overruled or whittled down by other opinions. Maybe other opinions that have distinguished the Jones opinion, they've distinguished it in such a way it more better fits your fact pattern, and you're going to rely on those opinions rather than Wagner. But still, Wagner is good law. Let's see. I can't remember. Do I have any? So pro tip 1, make sure you use the headnote treatment to find similar opinions to what you've already found. So in Jones v. Wagner, I do like Westlaw better for this approach. They're going to have headnotes at the beginning of the opinion that are dealing with a specific rule of law or a specific analysis. So you can not only navigate your opinion by clicking on the headnote link and getting into the opinion that talks about this small subset of the opinion, but you can also narrow your search by other headnotes. You can shepherdize by cases that have used a similar head note. So let's see. So an actor places branches, torches land another's project. It's a continuing trespass. So if that sort of fits the narrative of my opinion, I can shepherdize by that head note language and find several other opinions within whatever jurisdiction is dealing with that very, very narrow aspect of law. So similarly on Westlaw, you can do the same thing. You can click on the head note link, find other cases that have a very similar head note. And that's the way that the whole one good case approach to research becomes important. If you can find one good case sort of on point, you can use the one good case, use the head notes to find other opinions that are similarly situated. So that's a very important research tip. Number 2, use the filters to narrow the citation lists of your case. So in Citizens United, I do my Shepherd search. There are 12,687 citing references to Citizens United. So secondary sources, trial documents, all sorts of cases. But on my left column here, under citing references, I can narrow it down to cases, negative treatment, Third Circuit. I narrow it down to just 25. 25 cases negatively treating Citizens United in the Third Circuit. So I went from 12,000 citing references down to 25 that I'm probably most likely to care about. So that's my pro tip number 2. So let's see. On Lexis, Citizens United. Let's see. So here it is. Like a Pennsylvania appellate level state case, you're not going to have 14,000 citing decisions. So it's not that big of an issue. But if you're dealing with a federal issue, a lot of citations, you're going to need to want to filter it down. So positive, negative, neutral, others. So citing decisions, I'm going to click on them all. So, and then I could do the 200 opinions that followed Citizens United, go into my Third Circuit, my one Third Circuit opinion that positively treated Citizens United. So I can take my several hundred cases down to just one in my Third Circuit, because that's probably what I'm most focused on if I'm practicing in Pennsylvania federal court. Okay, so real quick here, wrapping things up about the legal research project. It'll be on your Twin site or on Canvas for David's class by tomorrow morning. It's going to be a fact pattern, state court fact pattern. There's going to be 6 questions, and it's basically asking you basically read the fact pattern, find a secondary source, couple secondary sources on point. Hopefully those secondary sources can lead you to a statute that's on point. The statute, the annotated statute then will lead you to, you need to find 2 cases on point. And then the case citations in the secondary source will lead you to more opinion. So bottom line, you may be able to answer all 6 questions just finding 1 secondary source. That's my pro tip number 500. A lot of times you can use a secondary source to answer the whole stinking assignment. So secondary source, statute, case law. It's a very general fact pattern. It's nothing too complicated. Shouldn't take you more than 30 minutes or so. And I think that's all I have. So are there any questions? Well, if not, then thanks for stopping by.
Thank you.
Thank you, Brent.
Thank you.
Thank you. Have a nice day.
Thanks, guys.